Call to order the meeting of the Planning and Zoning Board of the City of Tarpon Springs for June 15, 2015, and it's 7 p.m. Madam Secretary, you want to call the roll, please?
Mrs. Protos? Mr. Parker? Mr. Carr?
Here.
Mr. Seaman?
Here.
Mr. Gialusis? Ms. St. Arnold?
Here.
Mr. Hasse? Chairman Vinson?
Here. Thank you. The next item on the agenda, I don't think we need the quasi-judicial announcement since our only item is a legislative matter rather than quasi-judicial.
That is correct.
And so we'll forego that matter. So that brings us down to item number 3, application 15-48, Land Development Code Amendment regarding Ordinance 2015-14, amending Comprehensive Zoning and Land Development Code, Article 4, Special Regulations, Section 52.00, alcoholic beverages by providing for administrative review and issuance of conditional use permits. And our planning director will now give the staff report.
Thank you. Heather Erler for the Planning Department. The City of Tarpon established the alcoholic beverage ordinance in 1990, and the ordinance was intended to regulate the sale and consumption of alcoholic beverages within the city. The City Commission has received several inquiries from business owners, especially those in the CRA district, about the possibility of streamlining the permitting process, and part of that was looking at alcoholic beverage licenses and how they were actually the process through which that they go through. And basically what I've compiled here in the staff report is just some additional facts and information about what the staff's been seeing as we move through the process. Generally, it takes approximately 2 to 3 months to get through the alcoholic beverage license process for businesses that are newly moving into Tarpon. And basically at the request of those business owners to the board, we're seeking to do some changes to the ordinance that basically regulates alcoholic beverage licenses. And specifically, they're looking to do is in the first section, Section A, is instead of the Board of Commissioners being the authority under which that these beverage licenses are actually going to be issued, the conditional use process would still happen. It's just it would happen with the sign-off of the planning director and the city manager. So that's the major crux of the change here. There's some other additional changes in provisional L, and again, this is to mirror because we're changing it from the city commission and under which they would look at the compatibility of a business and having alcoholic beverage license and the criteria for measuring the distance criteria between uses that aren't necessarily compatible with alcoholic beverage license or types of businesses that are having alcohol served at their business. So that being the case, this essentially amends that language that looked at for the board of commissioners down to, again, the city manager and the planning director reviewing that for the distance criteria. The next change is actually in item M, and again, this is looking to add some additional information on what needs to be provided as part of the conditional use application. Again, this goes back to kind of what we've been discussing, is getting the materials in-house that we can actually make our decisions from and make good decisions from those. And then the final section is Section M, and again, that's just getting some additional information as far as the ownership of the establishment that we're actually going to be serving the alcoholic beverage license, would actually be serving alcohol. So with that, that's really all that I have here. It's not a lot of changes, and unless you have questions, I'm here to basically collect information on what you feel and what your interest is in seeing this move forward and to seek your recommendation.
Thank you very much. Are there questions of staff from the board?
I've got a couple. So right now it comes to us, then planning and zoning, and then it goes to the Board of Commission to be
Correct.
checked off on, right? So
Correct.
What happens if the planning director and the city manager maybe doesn't see something eye to eye on a potential property? Is there would the applicant then go to a board like of appeal it to the commission, or?
They probably would go through the appeal process for the conditional, for any type of conditional use. There is an appeal process specifically. I don't know if there's actually one in here. But there is an appeal process under which that they can appeal decisions.
And Jim, if I may interject here, Randy Moore on behalf of the town attorney. Section 215 of the code provides that the Board of Adjustment will hear and decide appeals of administrative decisions where it's alleged that there's an error in any order, requirement, decision, or determination. So your Board of Adjustment would serve as an appellate body to the decision made if somebody objects to what the final decision is. I don't know that that necessarily resolves the inquiry you posed as between the two of them, between the planning and zoning director and the city manager not seeing eye to eye. But if and when a decision is reached and an applicant is not pleased with the decision and wishes to appeal, the Board of Adjustment would be their most appropriate venue.
Okay, thanks.
Any other questions, Mr. Carr?
That's it for me.
Anyone else have questions of staff? Okay, at this time, the board is open for a motion.
I'll make a motion to approve application number 15-48.
Second.
Aye.
Okay. Ms. St. Arnold seconded the motion. Discussion on the motion.
This is great for the city of Tarpon. Anything that could be streamlined for our businesses here is a wonderful thing. I always thought this was quite unique that we had to approve these every time they came up. So,
yeah, any place else I've ever been, this wasn't an issue, and it seems like it's removing a cumbersome impediment to development.
My opinion is a little bit contrary to those expressed. Although I like to see things streamlined for business operations, I think often, and we generally don't have troubles with these, but what we do often do is provide conditions under which the license would be granted, additional conditions.
Sure.
And so it does take some discretion, and my problem is when you give discretion to an individual in government, you sort of open the door for misuse of that discretion or abuse of it. And that's why my question to the city attorney earlier the week after I read this was about the appeal process, because I was concerned, well, what if someone, doesn't get along with, the city manager or the city staff and gets denied, is there a way to appeal it? And there is a way to appeal it, although, that's cumbersome and could be expensive. My feeling would be because of the sensitivity to the residents that might be affected by these kind of businesses, I would prefer it to be within the board and maybe even skip the P&Z so it doesn't have to go for 2 meetings, perhaps. But I would much rather see a board that has some accountability to the residents, whereas you have city staff that are not really accountable. They're only accountable to the city manager or to the board of commissioners. But so that's my personal feeling.
If I may interject, just for the purposes of clarification, I would add that noting your points that while as drafted this would vest more authority within the planning director and the city manager, both those individuals would still be capable. This is still a conditional use permit, and it doesn't remove it from that section, so conditions could still be imposed. I understand your point that it's fewer people giving input on that point, but just so there's clarity, this does not eliminate that. This does not remove this from the conditional use process. It's just different input in that system.
Right, and I understand that, but it just seems to me that when you have people that aren't as sensitive to the residents who may come, they don't have a forum to object, whereas the procedure now, whether it's before us or the city commission, nearby residents or other businesses can appear and voice their objections or concerns, whether it be loud music that would be, or how late does the music play outdoors, that sort of thing. That's a common problem we have with organizations that serve alcoholic beverages. And so I think they might have a deaf ear, or there's no forum to make those objections heard. And so that's why I would prefer it go to the city commission. I do want it to be expedited or, streamlined. I have no problem with streamlining the procedure. Any other comments from the board or any other discussion before we take a vote? Okay. Roll call, please.
Mr. Carr?
Yes.
Mr. Seaman?
Yes.
Ms. St. Arnold?
Yes.
Chairman Vincent?
No? Okay. I guess that carries 3-1. Okay, because on some matters I know we have to have 4 votes on, but on this type legislative matter, so the motion does carry. And so that takes care of item number 3. And that brings us to staff comments.
I don't have any comments at this time.
No.
Okay. All right, that brings us then to number 5, board comments.
I have just kind of a question more than a comment, and I think I've sort of voiced it once before, but, and I know people that have been here for a long time said, you used to have like an agenda session and meet and discuss some of these things before the final proposal comes, and they stopped doing that, and now we can't do that or something. Is that correct?
I think what you're referring to, I know Ms. Protas from time to time has made those type of comments, but and I don't know about this board ever being able to do that, but the Board of Commissioners, at least back when I was on it, they would have a work session where it would be open to the public. It wouldn't be a private session. It's a public meeting. But they would discuss things and hear from the public about issues, and they wouldn't take a vote at that particular meeting. It would have to then go to their next meeting that wasn't a work session. It would be a regular session where they would take their action.
I've never seen it on this board or the board. When I came from Dunedin, we didn't do that, and Dunedin didn't have any of that either.
We're an advisory board anyway, and
Right.
so it doesn't make a lot of sense for us to do that. If the board wants to, I guess, have work sessions, I guess they can do that or something like that. But obviously with the Sunshine Law, whatever meetings there are of any board, it has to be open to the public and advertised.
Well, and it was. I mean, where I come from, an agenda session prior to the actual meeting is part of the proceedings with the Planning Commission. And it worked out a lot of these things and resolved a lot of the things like your concern tonight, which I think is a very legitimate thing, because those comments could go back to the people developing the ordinance, and some adjustments could be made. By the time we get things, they're finalized and it's a yes or no vote, when it would really be nice at times to be able to make comments on things and potentially affect the process instead of having to vote yes or no.
Well, the TRC, or the Technical Review Committee, this serves that function somewhat, although the public usually doesn't participate in that. That's staff from various departments going over the plan or the application with the developer or the business owner. And then, of course, I know staff would point out issues that they're concerned about, whether it's the fire department or the planning department or whatever, and have the applicant address those issues before it comes to us. But the public usually isn't involved in that.
However, the TRC meetings are open to the public, and as such, I mean, not that I can have all of you guys come to all of those meetings. Let me know ahead if you're interested, if there's an actual topic you're interested in, because we have to make sure that there's not a quorum of you there, because then we would have to advertise that you were having a public meeting as well.
Yeah.
But those are open to the public, and the general public is welcome to come on any of those applications and participate in at least the discussion to find out what's going on if they have a specific interest. Now, again, TRC is just, you have to know that those meetings are going on, because usually that's early enough in the process that I haven't necessarily posted the property or sent out the legal advertisement for whatever the next step might be. So it's still very early in the process formulating the application and working with the applicant.
Is the agenda for the TRC posted on the website anytime before that, the meeting?
Yes, the agenda is generally posted the Friday before, sometimes even earlier on the website, and it's posted on all the doors here just as your agendas are. So it is available to the general public to come into those meetings, but they would need to call the department and ask, Our schedule for TRC, just like our other boards, are online as well, so you can actually find out the dates and times of the meetings as well. So
Does TRC meet weekly or monthly?
it meets twice a month, and it's basically meets before a board hearing and after the planning, the Board of Adjustment, the very next morning after Board of Adjustment is usually the second meeting of the month.
Thank you
So,
very much.
you're very
For
welcome.
that information. Any other board comments? Is there a motion to adjourn?
Yes.
Motion
Second.
by Mr. Carr, seconded Mr. Seaman. All in favor?
Yes.
Aye. The meeting's adjourned at 7:17 p.m. Thank you.